The HR director slid a manila folder across the conference table like she was dealing cards at a casino. "Rachel, we have evidence you've been conducting meetings with our direct competitors." 3 executives flanked her, arms crossed, faces arranged in practiced disappointment. "Building security logged you leaving the premises multiple times to meet with individuals we've identified as working for rival firms." I said nothing. "This constitutes a serious breach of your employment agreement. We're terminating your position effective immediately." They expected panic, tears maybe, some kind of desperate explanation. Instead, I leaned back in my chair and smiled. "You caught me." The HR director blinked. That wasn't the response she'd rehearsed for. "I'm sorry?" "Those meetings you photographed? You're absolutely right. I was discussing sensitive technical matters with outside parties." The executives exchanged confused glances. "What you failed to investigate," I continued, "is who those individuals actually were." I pulled out my phone, opened an email, slid it across the table. Those weren't competitors. Those were patent attorneys from Morrison & Whitfield, one of the most respected intellectual property firms on the West Coast. The color drained from the HR director's face. "We've spent the past 6 weeks documenting how Axiom Technologies has been using proprietary systems I developed before my employment here, systems I own, personally." I stood up. "You'll be receiving a cease-and-desist letter within 72 hours. I'd recommend having your legal team available." I walked out. Nobody followed me. Now, before I break down exactly what was in that cease and desist, and trust me, Axiom's legal department absolutely panicked when they saw it, let me ask you something. If you've ever had a company try to claim ownership of something you created, if you've ever been accused of betrayal by people who were actually the ones taking advantage, you need to be here. This channel shares experiences of people who protected themselves when nobody else would. We're building something real, a community that understands the difference between loyalty and exploitation. If you're among the first 1,000 to subscribe, you're joining the foundation. Welcome to something different. Now, let me explain the 6 years that led to that conference room moment. My name is Rachel Bennett. I'm 35 years old, single by choice, and until recently I was the lead systems architect at Axiom Technologies, one of the fastest growing industrial automation companies in North America. This is the account of how they fired me for alleged betrayal, and why that firing cost them access to technology worth more than their entire annual revenue. Understanding what happened in that conference room requires going back to where my career actually began. I studied computer engineering at UC Berkeley, graduating near the top of my class with a focus on machine learning applications for manufacturing environments. This was 12 years ago, before everyone suddenly became an AI expert. Back then, applying neural networks to industrial systems seemed almost experimental. My senior thesis proposed an adaptive quality control system that could learn defect patterns in real time. My advisor called it theoretically interesting but practically premature. The manufacturing world wasn't ready for that level of automation yet. I disagreed. After graduation, I spent 3 years at a small robotics startup in Oakland. The company eventually failed, underfunded and ahead of its time, but those years taught me more than any academic program could. I learned to build systems that actually worked in chaotic factory environments. Dust, vibration, temperature fluctuations, human error, real-world conditions that laboratory prototypes never anticipated. More importantly, I started developing something entirely my own. During evenings and weekends, using only personal equipment and my own research, I created the foundation of what would eventually become the Aurora framework. Aurora was an adaptive monitoring system that could integrate with virtually any manufacturing equipment. It learned operational patterns, predicted maintenance needs, and identified quality issues before they became costly problems. Nothing like it existed commercially. I filed my first patent application at 27, then a second, then 4 more. By the time Axiom Technologies recruited me, I owned 6 patents covering various aspects of industrial monitoring systems, patents they apparently never bothered to research thoroughly. Axiom found me through a conference presentation I delivered in Seattle. The company had grown rapidly through acquisitions, assembling a portfolio of industrial automation products that served manufacturing clients across multiple sectors. Their chief technology officer, a man named Douglas Mercer, approached me after my presentation. "Rachel, your work on adaptive monitoring is remarkable. We've been developing similar concepts internally, but nothing approaching your level of sophistication." "I appreciate that, Douglas. I want you to consider joining Axiom, lead our systems architecture division, help us build the next generation of industrial automation." The offer was substantial: salary, equity, resources to expand my research, everything a young engineer could want. But I'd learned from previous experiences to protect myself. "Before we discuss details, I need clarity on intellectual property terms." Douglas waved dismissively. "Standard arrangements. Anything developed using company resources belongs to Axiom." "What about pre-existing intellectual property, systems I've already developed independently?" "Bring whatever you have. We'll license it appropriately." That phrase, "license it appropriately," would become critically important later. I joined Axiom at 31, single, focused, and ready to build something meaningful. What I didn't anticipate was how quickly appropriate licensing would be forgotten once my systems became essential to their operations. The first 2 years at Axiom were genuinely productive. I expanded the Aurora framework significantly, adding capabilities that pushed far beyond my original patents: new machine learning models, enhanced sensor integration, predictive algorithms that reduced equipment downtime by measurable percentages. Clients loved the results. Axiom's reputation grew accordingly. Douglas positioned me as the technical face of major sales presentations. Fortune 500 manufacturers wanted to hear directly from the person behind the systems they were buying. I traveled constantly: Detroit, Houston, Chicago, international trips to Germany and Japan, where industrial automation commanded serious respect. My personal life became whatever happened between flights. Dating felt impossible when conversations inevitably turned to, "What do you do?" and the answer required explaining concepts most people had never considered. My mother called every Sunday without fail. "Rachel, are you eating properly? You sound exhausted." "I'm fine, Mom, just busy." Busy isn't a life, sweetheart. Busy is what happens while life passes you by. She wasn't wrong, but the work mattered to me in ways I couldn't easily articulate. Every factory running more efficiently, every quality defect caught before it reached consumers, every maintenance problem predicted before equipment failed catastrophically. Real impact, measurable improvement, systems I'd built protecting processes and people I'd never meet. That meaning carried me through the exhausting seasons. What I didn't realize was that Axiom's leadership viewed my contributions very differently than I did. Year 3 brought the first indication of trouble. Axiom prepared documentation for a major investor presentation. Douglas asked me to review the technical sections for accuracy. What I found disturbed me significantly. The materials described Axiom's proprietary Aurora monitoring platform as if the company had developed it internally. My name appeared nowhere. My patents weren't mentioned. My pre-employment work was presented as corporate innovation. I confronted Douglas immediately. "The Aurora framework predates my employment here. We discussed licensing arrangements when I joined." Douglas shifted uncomfortably. "Rachel, those investor materials require careful positioning. Acknowledging external IP creates complications." "Complications for whom? I own 6 patents underlying these systems. Patents that Axiom has invested substantially in developing further. Your original work is just foundation." foundation without which nothing else would exist. He ended the conversation without resolution. I should have escalated immediately, contacted attorneys, demanded formal clarification of intellectual property ownership. Instead, I rationalized his behavior as investor relations strategy. Surely, internal acknowledgement of my contributions would continue even if external materials simplified the narrative. That rationalization cost me significantly. The following year, Axiom underwent leadership changes that shifted everything. Douglas Mercer retired. Health reasons, officially, though rumors suggested the board had pushed him out over strategic disagreements. His replacement was a woman named Carolyn Fitzgerald. Carolyn came from the private equity world, no technical background whatsoever. Her expertise lay in maximizing valuations and positioning companies for acquisition or public offering. Our first substantive conversation revealed her priorities clearly. Rachel, I've been reviewing our intellectual property portfolio. Impressive scope, but the documentation needs strengthening. What kind of strengthening? Clear corporate ownership documentation, assignment agreements, transfer protocols, the kind of paperwork that makes acquirers comfortable. Some of that intellectual property doesn't belong to Axiom, it belongs to me personally. Carolyn's expression flickered briefly before resetting to professional neutrality. That's a conversation for legal, but I'd encourage you to consider how important corporate alignment is for everyone's success. The implication was unmistakable. Sign over your patents or face consequences. I smiled, nodded, said nothing committal. Then I went home and called an intellectual property attorney. Marcus Chen specialized in technology IP disputes for over 20 years. His firm had successfully defended individual inventors against corporate overreach in cases far more complex than mine. "Walk me through everything," he said during our first consultation. I brought documentation I'd maintained meticulously since before my Axiom employment. Patent filings with timestamps, development logs from my independent work, employment agreements I'd signed, agreements that specifically referenced pre-existing intellectual property. Marcus reviewed everything silently for nearly an hour. "Rachel, your position is considerably stronger than typical corporate disputes of this nature." "How so?" "Your employment agreement explicitly acknowledges pre-existing IP. You have documented patent filings predating any Axiom involvement, and crucially, you've maintained clear separation between your independent work and company-resourced development." "What does that mean practically?" "It means Axiom is currently using technology they don't own, technology they'd need your permission to continue using, permission you're under no obligation to grant." The realization was both empowering and terrifying. I'd been building systems that generated millions in revenue, systems that Axiom's leadership now wanted to claim entirely as corporate assets, and I had legal grounds to stop them. "What happens if they fire me?" Marcus leaned forward. "If they terminate your employment improperly, especially in retaliation for asserting your intellectual property rights, your position strengthens considerably." "So being fired would actually help me?" "Potentially, but you'd need to document everything between now and any termination." I left that meeting with a completely different understanding of my situation. The following 6 weeks became an elaborate documentation exercise. I met with Marcus and his associates multiple times, always off premises, always during personal hours. We reviewed every patent, every development timeline, every piece of evidence establishing my independent ownership. I knew Axiom monitored employee movements, badge records, calendar entries, the kind of surveillance that became normal in corporate environments. What I didn't anticipate was how aggressively they'd interpret my outside meetings. Carolyn summoned me to her office on a Tuesday afternoon. Rachel, we've noticed concerning patterns in your schedule recently. Concerning how? Multiple off-site meetings during lunch hours and after work. Meetings you haven't disclosed to your manager or documented in company systems. My personal time isn't subject to company documentation requirements. It becomes company business when you're meeting with individuals connected to our competitive landscape. She slid photographs across her desk, surveillance images of me entering Marcus Chen's law office, walking beside his associate in a downtown parking structure. Building security flagged these locations as associated with firms serving our competitors. The logic was absurd. Patent attorneys served multiple clients across industries. Marcus's firm represented companies in dozens of sectors. But Axiom wasn't interested in accurate interpretation. They wanted justification for what they'd already decided to do. I expect a full explanation within 24 hours, Carolyn concluded, or HR will become involved. I didn't provide an explanation. I called Marcus instead. They're going to terminate you, Marcus assessed immediately. Use the competitor meeting pretext to justify immediate dismissal. Can they do that legally? They can try, but terminating you for alleged competitive betrayal while actually attempting to steal your intellectual property creates significant exposure for them. What do I do? Let them fire you. Don't resist. Don't explain. Let them create a documented record of improper termination. And then we deliver the cease and desist. The plan was straightforward but required something I found difficult, appearing defeated when I actually held all the leverage. The HR meeting came 48 hours later. 4 people arranged against me in that conference room, the HR director leading with photographs and accusations, executives providing silent intimidation. We have evidence you've been conducting meetings with our direct competitors. I let them talk. Let them build their case entirely on misunderstanding. This constitutes a serious breach of your employment agreement. I waited until they finished. Then I smiled. You caught me. Their confusion was almost entertaining. These were people accustomed to tears, denials, desperate negotiations. Employees caught doing something wrong typically didn't admit guilt while smiling. Those meetings you photographed, I continued calmly, you're absolutely right. I was discussing sensitive technical matters with outside parties. The HR director's confidence wavered visibly. What you failed to investigate is who those individuals actually were. I produced my phone, opened the email Marcus had prepared specifically for this moment, showed them his firm's letterhead. Patent attorneys, not competitors. We've been documenting how Axiom Technologies has been using proprietary systems I developed before my employment here. The room went silent. Systems I own, personally. Systems you've been claiming as corporate assets without proper licensing agreements. The HR director looked toward the legal representative present, a junior attorney who clearly hadn't been briefed on intellectual property implications. You'll be receiving a cease-and-desist letter within 72 hours, I said, standing. I'd recommend having your senior legal team available. Nobody stopped me from leaving. Nobody knew what to say. The cease-and-desist arrived exactly on schedule. Marcus's firm delivered it directly to Axiom's general counsel, a detailed document outlining my patent ownership, documenting improper corporate claims to my intellectual property, and demanding immediate cessation of all Aurora framework usage. The impact was catastrophic. Aurora Systems monitored manufacturing operations for 37 major clients. Disabling those systems would create operational chaos across multiple facilities. Axiom's stock price dropped 11% within a week as rumors of IP disputes spread through industry channels. Carolyn Fitzgerald attempted damage control through intermediaries. She's willing to negotiate a reasonable acquisition of your patent portfolio. Define reasonable. The number they proposed was insulting, less than 1 year of revenue generated by systems I'd created. No. What would you accept? Fair market valuation plus damages for improper termination and attempted IP theft. The figure Marcus calculated exceeded $40 million. Axiom's board convened emergency sessions. Their strategic deals depended on clean intellectual property ownership. My claims created complications that threatened pending deals. 3 weeks after my termination, Carolyn Fitzgerald resigned. The official statement cited strategic differences with the board. The actual reason was that her IP documentation initiative had exposed vulnerabilities she hadn't anticipated. The cease and desist arrived exactly on schedule. Marcus's firm delivered it directly to Axiom's general counsel, a detailed document outlining my patent ownership, documenting improper corporate claims to my intellectual property, and demanding immediate cessation of all Aurora framework usage. The impact was catastrophic. Aurora Systems monitored manufacturing operations for 37 major clients. Disabling those systems would create operational chaos across multiple facilities. Axiom's stock price dropped 11% within a week as rumors of IP disputes spread through industry channels. Carolyn Fitzgerald attempted damage control through intermediaries. She's willing to negotiate a reasonable acquisition of your patent portfolio. Define reasonable. The number they proposed was insulting, less than 1 year of revenue generated by systems I'd created. No. What would you accept? Fair market valuation plus damages for improper termination and attempted IP theft. The figure Marcus calculated exceeded $40 million. Axiom's board convened emergency sessions. Their acquisition strategy depended on clean intellectual property ownership. My claims created complications that threatened pending deals. 3 weeks after my termination, Carolyn Fitzgerald resigned. The official statement cited strategic differences with the board. The actual reason was that her IP documentation initiative had exposed vulnerabilities she hadn't anticipated. If this resonated with something in your own professional experience, if you've ever created something valuable and watched others try to take credit, if you've ever been accused of betrayal by people who were actually betraying you, subscribe and become part of this community. Every week we share experiences of people who protected themselves when nobody else would. Drop a comment telling me about a time you had to defend something you created. I read every single response. And check out that video right there, another experience you absolutely need to hear. Until next time, protect what you build, document everything, and never explain yourself to people who've already decided you're guilty.